I was an attorney. I was a big firm, got out of law school, big firm, did general litigation, and somewhere along the way, that one of those areas in your brain that had been dormant basically my whole life kind of started to warm up, and I just got consumed with this urge to create something beyond. Forgot to bring my timer.
Oh, we've got a timekeeper.
Yeah, okay. I got consumed with an urge to create something more than just lots of boxes full of documents, which is what I was doing at a big firm. And I realized that photography was calling to me, and that that act of creation was really a passion that I have, to tell stories. And I eventually dropped out of practicing law and became a full-time attorney. I'm here today in part through my proud membership with the American Society of Media Photographers, who is leading a charge to try to fix a lot of the problems that I now as a photographer are running into with trying to exist in a society, in a digital world where our copyright system is not really helping. So, and in that experience, I've been exposed to the plight of a lot of other types of photographers, for sure, and small creators like graphic artists. And like Sandra said, the stories are all very similar. We're all struggling. So I wanted to kind of lay out a little theme, which is essentially that for small creators, and especially for high volume, lots of work, but low income from that work creators, this system is really whacked out and broken. And it is not working as a bridge. I would propose that it's working as, in many ways, as a roadblock to actually us, fully being able to survive as professionals and contributing members to our creative economy. I have a few slides to kind of help illustrate that. As a photographer, I look at the Constitution and say, yeah, I seem to have a right that's built into our Constitution. I look at how that Constitution has been interpreted, which is that the framers intended copyright itself to be the engine of free expression, and I go, yeah, I have a right that I should expect my government to help protect. And I don't think our government, through all the various parts of it, between Congress and the Copyright Office and all the this and the that and the finger pointing, is making this thing work for us, the bottom level creators in this nation. And trying to think about this, and hopefully everyone can see this, I'll explain it, but I did basically 3 tracks as I started to try to think about how we got to this point. Track 1 is sort of the timeline of the U.S. Copyright Office, in which, we start off in 1790, we go, kind of starting to work this thing out, photography kind of gets invented, the Copyright Office and whoever it was at that point in time recognizes photography as a valid form of expression to protect. We trudge along, we get to 1976, we do a great big, we do it, we do the deal. It's set in stone. And as far as I'm concerned, it hasn't really moved much since then. Now let's go back to the other track, which is photography. On the photography track, boom, we get new technology. 1839, we get the daguerreotype, really starts to set things off. And so now we get this class of professionals who are able to make a living as photographers. And then after that point, we get disruptions, technical disruptions, like the introduction of film. We get a disruption like the introduction of color film and Polaroids and SLRs, more compact cameras. And all of those disruptions, photographers, like anybody else, had to just adapt, adjust to the changing technology or die, right? That's the way, that's kind of what the economic people out there say is supposed to happen. It's healthy, it sorts you out. If you're a dinosaur and you can't coexist, sorry, we moving on. The second part about this era is that it did create a class of people who could make a living as professional photographers. Little towns would have You know, their guy who would be a photographer, and they'd sponsor the Little League team, and they would hire people. The third part about that era, I'm going to call this pre-digital, is that it also allowed, it was hard to infringe. Analog is hard to infringe. It's hard to copy. Now let's step into this digital era in which we now have, you know, a digital world where not only can you photograph digitally, but you can transmit digitally. Initially, it wasn't that big of a deal for us photographers because you didn't have digital cameras. It was still analog. You had really low bandwidth. We were uploading 480 by, 640 by 480 pictures. So if somebody did clip it, big deal. They couldn't do anything with it. That changed. I'm kind of looking at about 2004, 2005, when we got hit by a cascade of events that totally changed our world. We get things like Google and Google search. They kind of come into play. Finally, digital cameras became pro-quality instruments, and people started buying them more than regular cameras. So now we've got a whole lot more demand, a lot more supply coming in. The iPhone starts a brand new digital revolution where now everybody on earth just about has a phone in their pocket. And you get this pop-up of mushrooms of people who are taking advantage of this new world, like Facebook and Instagram and Pinterest and Twitter, who their lingua franca, frankly, it's not just words, it's visual imagery, which in many cases is coming from us, and they're not paying for it. They're using it, and they're making the money, and we ain't. And then you get a lot of little extra things, which really put the squeeze on us. Bandwidth increased. Monitors went from little bitty tiny things to 4K monitors. Software allows you to interpret a tiny file up into a print. And here's the squeeze that we have as photographers. If we don't engage in this digital world to market ourselves, we die. This is not a technical disruption that we've ever faced in the past. It's an unfair one because what's been unleashed is a rash of infringements, and we have to feed that beast. We have to continue to put our images out there or we will die, which in turn leads to more infringements, and we are cascading downhill rapidly. The other part of this is that we have unleashed an infringement beast of epic proportions. So I'm going to flip to a few slides with that and then wrap this up just to show it. But we're looking at 4.5 billion internet users in the world. This was as of 2 days ago in a 24-hour period, including over 3 billion Google searches, over 40 million photos uploaded in one day on Instagram. This is a cascade of massive proportions. And what that done is it's flooded the market. So it's taken, on a supply end, it's really gutted us in terms of being able to make money oftentimes off of our imagery. That slide is just of Yosemite. And literally, there's like 10 pages of these pictures if you do a Google search or a DuckDuck search. So when you start to look at this, 3 billion images uploaded every day. According to CopyTrack, 85% of those images are unlicensed. 2.5 of those 3 billion images are stolen each day. And over $600 billion in damages, according to their estimates, are occurring to our creative people every day. Now, some of these are amateurs, and this is rough, and I'm not sure of the methodology, but the scale is massive. In effect, my point is we have normalized infringement. We have created a culture of infringement, and now we have to crawl back from that if you want us to survive. The infringements now are so bizarre and so brazen that you get situations where some idiot walks into an art gallery with his picture, he takes a photo of a famous photo that a real photographer had taken, and you can see, look right here. That's the museum exhibit. That's the label. And he takes that and he goes to his stock agency, since he's now a professional, and he uploads it. And Alamy, they apparently don't do any due diligence or care because they just put it right into their system. And then this magazine, which likewise didn't seem to really care, just said, well, I'm not going to think and actually wonder if this image is real. They're just going to clip it and use it. So now the guy who actually took this photograph is going, how in the hell did my image get onto this magazine through this veil of authenticity? It's surreal what's happening out there. And in case you think America's first is great all the time, well, we're first in infringements, according to CopyTrack. The bottom line is photographers are dying. We're at 34 grand a year, dropping 6% as a profession. And in my view, few photographers use copyright system. If we want to talk about the reasons why, I'd love to explain that. And I believe we need reform and modernization, and it's not just tweaks. We can't just polish a junker when it comes to high volume, low income creators and expect it to work. We've got to do some really big rethinks of what we expect out of the system and how we're going to achieve it if you're actually going to empower us and make us feel like we're a part of it, like our constitutional rights are actually being met. So that's my gist, and I'll wrap it up.
So we're going to bookend our patent presenters with our copyright presenters. So we'll move now to Benjamin Kwitek, who is president and CEO of InterForm.
All right, good afternoon, everybody. Thanks for being here. So in addition to being an inventor, I like to race cars. So I entitled the presentation Where Ideas Meet the Road instead of Where Rubber Meets the Road. So this is me driving a Porsche 911 Turbo S. And the idea here is that invention drives everything. So I once took a racing school with BMW, and the chief driving instructor there said, when you go around the cones, most people tend to hit the cones. And the reason why they hit the cones is that they're looking at the cones. And he said, to be a really good race car driver, you don't even look at the cones. You look at the spaces that exist between the cones. And after a while, your brain doesn't even see the cones. And I love this analogy because it's also true in life. We tend to stare at the problems in our lives, and we don't realize that opportunities exist between those problems. So I think as an inventor, you see problems of the world, but you're like, how can we fix that? How can we get around that? How can we make the world a better place despite these cones or problems that exist? So the idea here is that the road is difficult. If you think about what the public knows about an inventor, they think, okay, you have this flash of brilliance, you get a patent, and you become rich. That's sort of the view a lot of people have. And really nothing could be further from the truth. First of all, it's rare that you have a flash of brilliance. Second of all, once you do, then there's a long road with a lot of curves and unexpected obstacles in it. You've got to figure out how to make the thing or how to embody it. You have to file for the patent. You have to wait a few years for the patent office to give you a response. And perhaps if you're lucky enough to get the patent, then you've got to figure out, okay, how do I make money on this patent? And then once I make money on this patent, does somebody infringe the patent? And then if somebody infringes the patent, do they go to PTAB and throw the patent into re-examination? And then all of a sudden you become a legal expert and not an inventor anymore. So there's a lot of obstacles in getting from point A to point B. But the beauty is inventors are up to that challenge. And if the government can provide a framework that allows them to do what they do best, which is creativity and idea generation, then the whole entire economy moves forward very quickly. A person from the car industry quickly is Elon Musk. So at BMW's boardroom in Munich, Germany, they have a photograph of Elon Musk, because they'll tell you that more than Mercedes, more than Audi, more than Lexus or any other car company, they view Tesla as their primary competitor. Why? Because Tesla invented a whole new category, in essence, of performance-based electric automobiles. And now you have companies like Daimler, Mercedes-Benz, saying that they might not even develop internal combustion engines in the future because we've sort of moved beyond that era in the automotive space. So my next slide here is no speed limit. So if you've traveled on the German Autobahns, there's still sections that are no speed limit, and you'll see this sign, either the physical sign or a digital copy of it, projected in LED lights. So I've driven a lot in Germany, and I fell in love with this sign because to me, it represents not only speed, which I love, but the idea of no limits to life, that you're in control and it's about your capabilities and the limits of your imagination and the limits of what's possible. So I wanted one of these signs in my home office. So I asked all my friends at BMW and Germany and at Porsche, and they said, no, you can't get them. And if you steal one, you'll end up in a German prison, and that's not a good look for an American. So I came back to the States and I said, I'm going to start a company and we're going to import authentic German road signs. So long story short, I got permission from the German government, I got permission from the US government, and last year we sold more authentic no speed limit signs in the United States than were purchased for the German roadways, the German autobahns. But I love this idea of no limits because I think that's what our economy and that's what the world needs. I mean, we're faced with massive challenges, these huge problems, these wicked problems. But with inventors, there's no mountain too tall. Let's figure out a solution, and let's get there with no speed limits. So this is a Bugatti Chiron. Put your foot in it. So I once met Mario Andretti, and his advice, he said to everything, whether it's the wine business that he's in or whether it's owning race car teams, is that you've got to just keep your foot in it. Put your foot in it. In other words, just go as fast as you can. And he said that the races he won, he almost felt like he was completely out of control during the race because he had to push it to that edge to actually win the race. But I love that philosophy again, that you've got to push the boundaries, you've got to go as fast as you can, and you've got to just keep trying. Because ultimately, the future of humanity lies in people trying, experimenting, inventing, and innovating. So with that, sometimes failure happens. The famous NASA thing was that failure is not an option, but I would propose just the opposite, that successful innovators fail, and they fail often, and they get over those failures as quickly as they can. Cars crash, cars start on fire, people wreck, but you've got to get over it. And inventors are good at doing that, facing obstacles, getting beat down, figuring out what's the path around it. How do I rebuild this automobile? How can I make it better to where it doesn't start on fire the next time I do something stupid on the track? So failure is an option, and we need to encourage more of it. I think as America has become wealthier, we've gotten more and more afraid of failure because we desire security more. And one of the things that made America great, and the Constitution represented this with intellectual property protection, is that we take risks here. We're not afraid to start a fire. We're not afraid to light things up. Which leads to my next slide, let's start a fire. So I love this image for a few reasons. One, it's like a very simple car and a really determined, almost like a German engineer driving it, and the wheels are on fire. So how do we get people excited about changing the world and invention? And I think the patent system provides a really great place for that to happen because you can profit from your ideas. And when you profit from your ideas, you're more motivated. If somebody would have said to you this morning, if you get out of bed when your iPhone goes off, we'll give you $10,000 if you don't snooze, most of you would not have snoozed. Why? Because the $10,000 is a proper incentive. The same is true with our patent system. If I believe that I can make a lot of money from my inventions, that helps me get out of bed, that helps me solve problems, which ultimately benefits society, and everybody's a winner. And finally, the race is worth winning. So the idea here is that really, I mean, it's not an exaggeration to say the future of our civilization rests with innovators. If we don't figure out solutions to a lot of the wicked problems that we're faced with, we won't survive much longer. I mean, there's been the reports in the news of 11 or 12 years left. I don't think that's true, and I don't believe that's true. And if it's not true, it's because of technology, and it's because of innovators stepping forward and saying, we got to do better. Like, we've got to fix this problem. We invented our way into it. Let's invent our way out of it. And I truly believe that that's an important thing. One last thing. Are we okay on time? Okay, cool. So I was once at a talk, and there was this executive from, it was either Goldman Sachs or Smith Barney. And this was in Colorado Springs at the Broadmoor Hotel, which if you've ever been, it's a beautiful resort. It's about 100 miles from Denver International Airport. And at the end of his talk, he said, I'll never forget, I've got a bit of a problem. I've looked on my phone, and the airport that I'm flying out of later tonight is about 100 miles from here. And I've measured the distance my headlights travel, and it's only 300 or 400 feet. So how on earth am I going to find my way to Denver tonight so that I can catch my flight and get back to New York City? And of course, the audience was a little bit quiet, and they're like, this guy's a bozo. Like, who let him speak here? And then he, after a dramatic pause, he said, oh, that's right, the light travels with me. And I'll never forget that because it's exactly right. You never see your way to the finish. You just take it a step at a time, a mile at a time, 300 feet at a time. But you've got to have the faith and the trust that with a lot of hard work, with a lot of creativity, and with the help of American invention and global invention, that we can get there, and the race is worth winning.
Thank you.
Chicken Little.
So Josh Malone is also an inventor, and he's known for a bunch of balloons, among many other inventions. And he is our next speaker.
Thank you. We're going to have to let Ben go again after Kerry and I go, because he does kind of, we're going to go in a little dark place here. And he'll provide us the light afterwards. Just remember his speech. It's really great to be at CPIP. I've been involved in, unfortunately, I've been thrown into patent policy world and the legal world the past few years, and this is unlike any other venue. Usually there's a lot of law professors, a lot of attorneys, but they're all talking about other stuff. Like, it has nothing to do with innovation. The inventor is absent. And CPIP and the theme here, the IP bridge, that's what it's all about. And yet, all these other conferences I've jumped in on or spoken at or attended, it's all about dividing up the spoils that we created. And so it's good to recognize that. I'm really excited to be here. And the theme is the IP bridge. And here's my experience with the IP bridge with respect to inventions. And the IP, in that case, is a utility patent. This is the inventor in Monty Python. You didn't know there was an inventor in that. Right prior to this, at the Bridge of Death, Lancelot goes first, and he nailed all three questions. What's your favorite color? Blue. He passes on. So the inventor shows up, like, I got this. And so there's the P tab. And there's the inventor. You'll have to watch that clip again when you go home. I watched it like 5 times preparing, so it's great. Can you guys hear me okay in the back? Okay, thanks. So my background, I was at Texas Instruments for about a decade out of college. I worked in the DLP department making 1 to 2 million micromirrors flip reliably, a trillion cycles. That was fun, challenging technology. But it became a big business, and I was stifled, so I quit. I started developing a electromechanical paper cutter. So there was a need to be solved, and I found a way to solve it. And so now women and children and crafters, and they're now making their crafts at home with my device. At least they were for a while. That paid some bills. It was really fortunate. I made another product. I crashed and burned. And so I had a lot of attempts through a period of about 7 years, and was just barely kind of getting by, paying the bills, but not really getting ahead. And so it was kind of crunch time. And I had basically 3 weeks left before I had to go back to the corporate world, where there were no openings for independent-minded CEOs that wanted to define the company strategy. And so it was really desperate. And so I invented a bunch of balloons. It's the way you fill water balloons. And hopefully you're not still tying your water balloons, because that's old school. I solved the problem. It was the middle of winter in early 2014, about, what is that, a little over 5 years ago now. Put it on Kickstarter. So I put off going back to the corporate world, scraped together funds, put up a video, and that's when everything changed. And Kickstarter, we raised almost $1 million from 21,000 backers, and I was in business, so I had a lot of orders to fill. I had a lot of interest from retail and the toy industry, and they flew me out to New York City. I had a water balloon fight with Carson Daly in Times Square. He's actually pretty agile, so I had a lot of balloons, but I didn't connect. So, And then I partnered with a toy company called Zuru, family-owned business, and we went into production. So they brought a unique value proposition to the table, and that was how you going to make these things. We had to make billions of water balloons to meet the demand in the market. And so several other, I had kind of my own game plan. It was going to be a long-term effort, a lot of very capitally intensive. And other companies came to me with proposals like, we got a guy in China. I got a guy in China. What else you got? Well, that was it. Zuru had actually an expertise in automation. And so they were able to put together a proposal to build this in mass quantities at a high quality, competitive process, which was really good because we had competition. So before we really even got into production, it's a little bit out of sequence. The knockoff showed up on TV. So left to right on the screen there is my invention, and then as we came to market, the knockoff is the second one. Later on, it was enjoined. I'll tell you about that. And then they came out with the third one. I'm sorry, they came out with the next one, and then the following year there was another. So this was my life now. Was trying to protect my business. We were up against a company that's notorious for this. There's some big tech companies, the biggest companies in the world that this is their business. This one wasn't quite that big. This is a company called Telebrands. They're the as seen on TV juggernauts. They created this, more or less created this industry at the checkout aisle and on TV, a lot of impulse buy type stuff. And about 90% of it's a knockoff from what I can tell. And so when I saw that was who was behind this, I was pretty nervous. There's actually books been written about these guys. They started with knocking off Sony Walkmans and Thigh Master. They had Thigh Shaper, and you keep going. You got Amber Vision glasses. You got Pet Egg, Spin Mop, Pocket Hose. All those things that many of us have bought unwittingly are not all of them, but most of them are misappropriated from the inventor. And they've been sued 100 times or more, and they never lost. So this was my destiny. I got a patent in 2015. We're in Target there in Walmart, so we're just trying to survive. And then they don't care if you have a patent, right? I mean, who cares if you have a patent? And so we have to file suit. And that just turned into a sprawling, massive litigation. I have 5 cases in the district courts, 14 visits to the federal circuit, second highest court in the land. Went to the Patent Trial and Appeal Board 8 times on 6 patents. And we ended up, let me see, I'll get to the numbers. So why? Why don't they just respect my patent rights? Because they don't have to. So they hire experts and they hire lawyers and more attorneys, and they just keep going. And so some of the arguments they raised, a lot of validity challenges. So no one knows when a balloon is substantially filled with water. What does filled state mean? They argue everything, and it happens in high tech as well. It's just harder to perceive the nonsense. But I've talked to many inventors, dozens, if not hundreds of inventors who've sat through these hearings. They're like, these guys are complete morons. They don't know what they're talking about, and they won't let the inventor testify. So they argued about that, and then they argued about the same prior art that was on the face of the patent that the examiner looked at. No mistake here, no overlooked prior art, but they still get to argue about it. There's some of the numbers I mentioned. We were able to win 4 preliminary injunctions over 5 years of litigation. We got to 1 jury trial, had 29 lawyers working on it, 2,800 docket entries. We spent over $20 million in legal, fighting over water balloons, not smartphones. They argued all the major legal issues. Many of these are in limbo right now in our country. We don't know whether a patent's a property right or not. We don't know whether the Seventh Amendment doesn't apply. We know that now. The government, the DOJ, and the Patent Office are currently arguing that the Fifth Amendment doesn't apply either. That's where we're at. So the first part of the bridge, the first girder for the bridge is the toll. It's about $75,000 per week. So that's what you want to do if you want to get a patent. And so we had a first ever protest in the history of the patent office because the law wasn't working. They made a documentary about it. So girder number 2, that's mislabeled, is political influence. So I found this serendipitously, but things turned around after I shined a light on the abuse. The big guys got that. They got deep pockets and they got influence in the agency. So most of the creators, I don't think any of the creators, I just stepped into it. But here's the bright side, I won. So they surrendered about 4 months ago. They couldn't withstand it anymore. It had about 10% to do with the merits. I mean, I won. This was an invention, 63 years, first development in the field. It was well examined, so the merits were there, but it just didn't play a big role in the outcome. The outcome was we sold $200 million worth of water balloons and gave the money to the attorneys to crush these guys. So here's the bridge. From 1790 to 2006, the United States had a bridge that was intellectual property. Before that, you had to be a friend of the king, you could have a patent. Between 2006 and 2018, we went back to that old system. We don't have a bridge anymore. A bridge is political influence and lots of money. So here's the other option, right? You can invent for pleasure. There's nothing wrong with that. You just can't put a lot of capital into it. You can do it as a philanthropist, those of us that can afford it. Find a benefactor, like in the medieval ages. Germany and China are promising, and then there's trade secrets. Of course, that's not good for innovation or for knowledge, and it leads to protectionism and mercantilism and isolationism. So it's not good. The solution, I have a solution. There's handouts at the front corners here. Grab them on your way out, and we're going to try to fix it. But thank you.
Hi there, my name's Kerry Mozzie. I am a film and TV and classical composer. This is basically like the short overview of my story and the context that brings me here today. Back in 2006, when iTunes was still kind of a novelty, and this was way pre-streaming, I decided to release some of my music onto it. I own everything, my copyrights and my recordings. I figured I would dip my toes into that pool and just see what happens. Oh, there we go. Excellent. Okay. So I released my music on iTunes, and the craziest thing happened. A few months later, my downloads exploded. I'm a completely independent guy. I had no affiliations with anybody. But what I found was that people who liked film scores or instrumental music were an incredibly loyal bunch that would, if they liked what you wrote, they would buy it. And what I found then was that in this brand new digital marketplace, my downloads were growing every month. And then the next amazing thing happened, which was completely unexpected, which was that I started to get licensing requests for that music from people who had found it on iTunes. We want to use this piece in like a commercial or a movie trailer, or we want to use this album to underscore a documentary. And these placements grew in profile, kind of peaking between 2009 and 2012 with the shows Glee and So You Think You Can Dance, where Glee licensed one of my pieces as a recurring love theme throughout the series. And then one of the choreographers at So You Think You Can Dance had choreographed my works, which introduced my stuff to an entirely new audience. And this is the thing that led me one day to search my name on YouTube just to see what would come up. And I got maybe 40 or 50 results. They were the things that you would think they would be. Kids who had made Glee mashups of their favorite characters, and they put my music underneath it. It was cool. Like, I was actually a working composer, and I had something that was attached to this property that was really amazing. And it was around this time that somebody said to me, YouTube has this thing where you can upload your music to it, and it'll fingerprint it, and then it will find everywhere on YouTube that your music is. That thing we now know as Content ID. Anyway, long story short, it took about 3 years for me to get access to it. And once I did, I figured that the results I would find would match the results that I saw by searching my name. Big shocker, the results were very different from what I found. In the first hour that my fingerprints were live, it found 200 videos. 8 hours later, it was up to 1,000. By the next morning, 2,000 videos in my dashboard. End of that week, it was 10,000. And by the end of that first month, I had found 20,000 videos that used my work without permission. Here's the thing. These were not kitten videos or family slideshows with music under them. They were commercials. They were ads for corporations. They were web content. And these weren't unknown things. These were ads for the cars that are in your driveways and for the products that are on your shelves. They were recognizable brands. 6 years later into the Content ID process, I have about 110,000 videos in the dashboard. About 900 of those are actually licensed. So when I'm telling people this story, this is the point where they have like a really obvious question that they try to ask in the most polite way possible, which is, how do you have 110,000 uses on YouTube? Because I've never heard of you. And it's true, I'm not famous. I'm not Hans Zimmer or John Williams. God willing, someday, it's an aspiration. But the thing is, it was the perfect question. And the answer to that was actually twofold. The first and most obvious way was that someone bought my album and then edited it into a video. The second way was much more insidious, especially outside the US, which was that my music had been bundled into torrent files. So you'd have Epic Music Torrent, SoundCloud SiteRip, Film Score Torrent. This is how videographers ex-US were getting their music that they were using to make corporate content and commercials for major corporations. Some in the US, but mostly ex-US. So the result was that corporations were completely blindsided when I started to make claims against them for unlicensed music use because they had just trusted that the videographer had delivered them a fully cleared product, but they hadn't. So I should say this about Content ID. I don't use it to monetize the things that I find. I actually use it to police. I use it to take down infringing uses of my music, and then I try my darndest to bring that person to the table to do a license agreement. And this is the thing that brought me crashing headfirst into the brick wall that is our very broken DMCA and the takedown process. Because as I was doing these takedowns, I was getting emails from YouTube saying, we've received a counter notification from this company or this person saying that this is fair use under US copyright law. Now, 90% of the time, the people claiming fair use under copyright law for their luxury car commercial weren't in the US. These were claims coming from China and Vietnam, pretty much everywhere except the actual US. Anyway, what I quickly learned was that YouTube gave me a 10-day window. Said you have 10 days in which to file a lawsuit or show us a court order that you've obtained to keep this from going back online. And if you don't meet that deadline, they just restore the content. They put it back online. So I'm not a corporation, and I'm not somebody with a staff of attorneys who can file multiple court orders and lawsuits every week. So I was kind of left without a remedy. And that's been really, really frustrating. Basically, those things just go back online. And to the extent that they were monetized by the uploader or by YouTube, or usually both, they got to continue to monetize that. And I was left with no recourse. So some of this, when you talk about it, sounds a little bit hyperbolic. So what I wanted to do was put up here some examples of some of the unlicensed uses that I found in Content ID. Where you don't see names on these, it's because the settlement agreements had confidentiality clauses. Where you do see some names on here, it's because the companies that are mentioned ignored my lawyer's claims. Because they were foreign companies, my lawyers in New York, they knew I couldn't afford to get a litigator in their territory to pursue it. And so nothing ever happened. When you look at the actual list, it's kind of stunning. But it's really the unfortunate landscape that I think most independent creators are in these days. You just don't hear a lot about it because a lot of them don't have access to that technology like Content ID. So I'm an indie guy who's hoping that eventually the landscape shifts a little bit, hopefully more in my favor. Thank you.
I think each of you in your own way addressed kind of the culture of infringement that you experience. What might it take to change that culture, in your opinion? Anybody who wants to jump in?
I'll take a stab at first. I think each creator in each situation has got a different set of needs. I think, and again, this is a neophyte to I'm new to this, trying to figure these things out in terms of the copyright system, but it seems like a lot of times we try to build a copyright system it's kind of like one size fits all. And we have, many times, some really focused needs that just can't be accommodated by a one-size-fits-all solution. And so as we kind of embark on a process of modernizing this system, hopefully it will include not just technological improvements, which are needed, but a real rethink of some of the foundational aspects of it, which may get into, for example, for certain areas, ways in which we totally modify the deposit requirements or eliminate them in certain situations. Have situations where we maybe, if we do group registrations of photographs, the only way to keep the cost down may be to, like in patent, have a provisional examination so that the cost of the Copyright Office to examine that group registration of 750 photographs doesn't get passed to us up front. Again, because oftentimes we make very little on those 750 photos. We don't know when or if we ever will. And ultimately, at least, especially for our area, I think, if photography, especially if we're going to do high volumes of photographs, or we're going to get them into the system, ideally, I think that's what it's supposed to do, right? We're supposed to build our public collection, and we're supposed to build a public registry as well as protect the artist. Well, and for those large, high-volume deposits for photographers, as an example, none of those are going into the public collection from the Library of Congress. They don't look at them. And there is no public registry. All we've got is a system where we have to pay, we have to jump really bizarre hurdles. Don't get me started on publication in the digital age and photographers trying to figure out what that means. That's just it's a time bomb trap for us. And effectively, we have a system where we're paying in, we're not achieving any of the goals, and at the end of the day, we don't have an enforcement mechanism because it costs $400,000 almost to bring in a suit. And like many of these companies, they just laugh at you, say, sue me, bring it. And, unless we kind of make some big changes, I think it's going to be really hard to actually change that culture given how far we're into it. I'll leave this one first step. I think one little step, or maybe big step, is to pass the CASE Act so that we actually have a way in small situations to go to infringers and on ideally, from my perspective, lawyerless, cheap, easy way, get them into the same room. And, I think often what will happen is you'll just negotiate a fair price and go on. And maybe having that remedy will change the attitude of a lot of people who are infringing with abandon now to say, maybe I really should stop and think, because they may come after me and cause me some difficulty. So, for us at least, it's multidimensional, and there is some hope, but it's going to be a lot of work. And when you're trying to navigate through changes in the Copyright Office that we want, and then statutory changes that have vested interest in keeping them the way they are, dysfunctional as it is, and the lobbying power of some of those interests, like the people who are, the big companies that are profiting off this system, it's quite daunting, frankly. But,
Kerry, did you want to add anything from your perspective?
Yeah, because someone did ask me once in a Twitter exchange with one of those IP attorneys who doesn't like IP, like they're trying to kind of dismantle from the inside, said, okay, so what's your ideal situation? If I could grant you one wish that was a fix, what would it be? Which was a great question, like if I could have one thing. And the one thing in my circumstance, and I think it's probably similar for photographers, is that if I issue a takedown on something, it should stay down. Unless that person can send you a license and say, sorry, you made a mistake, here's the license I have for this use, which is really kind of a no-brainer. But what that person can do, because they're kind of inoculated against harm, is they can just click the button, and this is especially and specifically to YouTube. If you want to challenge a takedown that you get on YouTube, there's a drop-down menu with two options. One says, I have a license for this use, and then there's a little comment field. And the other says, this is a fair use under US copyright doctrine, blah, 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 blah. Now, you can be in China, and you can call it a fair use under US copyright doctrine. The thing is that then puts the onus on you to bring about a lawsuit or a court order within 10 days. And I think a really simple fix would be, okay, you've challenged this. I receive it immediately from YouTube. Either show me your license or tell me if you think it's fair use. And I can decide if I think it is or not. And if you don't like that decision, then you can sue me. Because when you're somebody who writes underscore and someone uses your music in its entirety under a TV show or a promo or a commercial or something, that's not fair use. If you're gonna take my piece and analyze portions of it in a video and talk about it, that's fair use. I'm not gonna have a problem with that. You put it under a luxury car commercial and then you send me a thing saying it's fair use, that's when we lawyer up. And I can say that because I don't work with big law firms. I have 2 lawyers. It's a small operation, but they're really good. And sometimes you have to take that step. I'm lucky that at this point in my career, I can afford to do that selectively, very selectively. Like, you really got to pick and choose. But most times, there really is no solution. You just kind of have to take the hit and keep on walking.
Ben, as our optimist on the panel, what can you suggest?
I mean, so economists have this expression that there's no such thing as a free lunch. And I think over the past, decade and a half, 2 decades, we've sort of lost sight of that. We think, wow, Google's amazing and it's free. Facebook is amazing and it doesn't cost me anything. Home Depot and Walmart are fantastic because I get all this stuff for cheap prices. But the economic truth hasn't disappeared. In other words, there's still costs to everything. And what we've realized with Facebook and Google is that the cost is loss of privacy, ads, a lot of things that are now starting to come to light. And I think when we look at companies that have sold a lot of cheap goods, the loss there, or the cost there, is that there was a disrespect for intellectual property. So economies like China fueled low-cost products that helped the American economy, but at the expense of inventors and creators. So the question is kind of, how do we get the public or the culture to shift to where it recognizes, to paraphrase Taylor Swift, valuable things should be paid for. And creation, whether it's music, whether it's inventions, whether it's photographs, have value. And if they do have value, how do you make sure that that value is given to the creator in a way that makes economic sense for the person doing it, because then that's the incentive for them to create more. If you take away that incentive, again, you may have people doing things from the goodness of their heart or wanting to make the world a better place, but what we've learned is that capitalism and profit really are the best motivators for global change. The reason why 1 billion people have been lifted out of poverty in the last decade or two isn't necessarily because of the UN and charitable organizations. It's because of people getting jobs and people, living in such a way that they contribute to the global economy. So the question is, how do we kind of refocus on our culture to say, whoever creates the value should get rewarded for that value?
So how do we educate people on the value of IP in this current situation?
I mean, I think it starts with all of us. It starts with people like Taylor Swift, fighting Apple and saying, hey, I need to be paid, and other artists that aren't as famous as me need to be paid for our contributions. And people just understanding what IP is. I think we live in sort of an open source world where, again, we tend to think things are free and easy, but the reality is there's always more behind the scenes than people appreciate. And how do you shine a light on that such that everybody can say, hey, you've worked really hard on this, you deserve it, you're not just an overnight success. And once that happens, I think hopefully there's a bit of a ripple effect and the economy starts to change to reflect that.
Josh, do you want to jump in with thoughts on what it might take to change the current culture?
Yeah, now that I had time to think about it, thank you. That was helpful, actually. So I think it's about telling the truth to American citizens and inventors. Investors already know it. If you look at the data on where investors are putting their capital, it's not in cutting-edge hardware and technology that is patentable. And then educating inventors. I mean, most inventors I talk to, it's getting better, but I still say 90% of them think that a patent is a property right. They think that a patent is the right to exclude others from using the invention. And you're still teaching this at law school. I mean, this school right here is teaching these things that haven't been true. So we really have to kind of embrace, our situation. There's no rule of law when it comes to patents. The big guys win. The Supreme Court said you don't get to exclude others. They will decide who can use your invention and how much they'll pay you for it. The Supreme Court said in oil states it's not a property right. Under the separation of powers, it's not a property right under the 7th Amendment. And now the DOJ and the Patent Office is arguing in the court that a patent is not a property right under the 5th Amendment. Well, then what kind of property right is it? So we're going to have to tell the truth to people. Inventors need to abandon the United States patent system. It's a waste. It's just like the invention promoters. It's a scam. If you're an attorney, you should be telling your clients, don't pay me to give up your secret to the Patent Office, because you're not going to get protection in exchange. So the key here is to accept the situation, and knowledge is the power that we're going to have, and we're going to have to understand how bad it is. We can talk about intellectual property and a patent system, but it should be in a historical context. That window I showed in my slide from 1790 to 2006, that was a glorious time. And we need to talk about it in the past tense.
Yes. Earlier today, we were talking about how universities create so much content now. In my situation, that's part of the problem, is that when the pirate is the university or the pirate is the state, and fighting them in a copyright court is a nightmare. And I'm involved with an unbelievable court case against Texas A&M University. DMCA, copyright, and instead of dealing with the problem, they try to claim sovereign immunity. And any of y'all, pay attention to the court case that goes in front of the Supreme Court in about a month, Allen versus Cooper. That is a big test to try to deal with a problem that has been going on for 20 years, at least. And I understand and have great empathy for a lot of the things y'all have been going through up here with this. And I'm just trying to tell you that we all have to work harder. We have to work together. It is only with people like us in this room today and others that we begin to change the system, change the courts, change the way things are taught, because at the end of the day, if we don't take those stands, then those changes are not going to get made. And I don't think that a lot of the people that work for universities or states, that they're bad people. It's just that some of the people that run the show for them make some really bad decisions, and that impacts all of us. So I just encourage y'all to pay attention to this case in the next month. It's going to get a lot of attention, but that's just the beginning of hopefully a off-ramp to change this problem, to try to fix 20 years of major mistakes that have been going on with the courts regarding copyrights. So, good luck.
Thanks for the reminder. Are there others in the audience with questions or comments? Yes.
So, Mr. Muzzey, you were talking about your enforcement actions, and it seems like so much of your enforcement action was dependent on a tool that was provided to you from YouTube, Content ID.
Yeah.
And I don't know the story on how YouTube actually was convinced to provide that to creators. And I also don't know how accurate you find it to be. Does it overcapture? Does it undercapture?
You know what? Those are both really good questions. And the first one is really important to understanding the context in which YouTube uses Content ID and why they have it. It was basically a remedy that they were employing to keep from being sued out of existence by the major labels and major music publishers. Like, we're going to allow you this tool, and what you can do is you can see everything, your music will turn up, and we'll have a blanket policy in place, and if you want, you can choose to monetize it. Monetizing it means that you're issuing a micro license. So you've got a blanket policy from the label and from the publisher. So realize that 99% of the music that you're seeing and hearing on YouTube it comes from major labels. It's people that you recognize. So that's what Content ID has always been. It was their safety. It was like their last ditch effort. As far as accuracy, the accuracy is really, really good. I hear a lot of anti-copyright people talking about, can you believe this video got taken down because it had this classical piece of music in it? Like, there's always going to be one example that somebody tries to explode into, like, the macro example of YouTube. When the truth is, with 110,000 claims, I think I've had between 10 and 20 false identifications where I listen to it and I'm like, oh, that's not my piece. The problem and the thing it identified was that I had used like a drum loop or something that was very publicly available, and it heard and captured that. So its accuracy is really good. Even if people are time shifting or pitch shifting the music to avoid detection, it can still find those. And I also have access to the publisher dashboard, which is on the composition side. And I think this is the piece that a lot of people don't realize, is that it's not always identifying the sound recording. In the case of a couple pieces that I have that are really popular, it identifies the actual composition, like the notes of the composition, not the recording. So the accuracy is really good. As far as being allowed into it, I will say that they typically don't let indies into it at all. They just don't. It was a very long and windy road to get me into it. I won't say how, but I'll just say that I was lucky. I was really fortunate. And I actually had examples that I could show them by saying that, like, okay, there's this video where this guy has an overhead camera on his piano showing you how to play the love theme from Glee, the little piano piece that they licensed for me. I need to be able to capture that publishing and monetize that, because that thing's got 100,000 views on it, which was part of the reason that I was able to get in. The catch, or I guess the problem that most independents have, is that you can access it if you use a third-party service like AdRev. You'll see AdRev a lot on YouTube videos, which is Content ID. It's just a service that sits on top of it, so that's your portal into it. The catch is AdRev is free to use as long as you're monetizing what you find. it's not that they don't let you do takedowns, but they expect you to be monetizing. So as long as you're okay monetizing the car commercials and the appliance commercials and all that stuff that didn't license your music in the first place, then you're great with ad rev. But the 25 cents you're gonna get from that luxury car commercials monetization on YouTube, because that's about what it is like 25 cents to $1, is nowhere near the 15 or 20 grand you should have gotten for the master and sync fee for the commercial in the first place, which aired on TV for X number of years before it found its way to YouTube. I think the answer is to let more indies into Content ID. That creates a world of hurt for YouTube, unfortunately.
Kerry, before we move on, you are talking about YouTube, but what has your experience been with other platforms like Vimeo?
That's a really good question. I don't know if people here are familiar with Vimeo. It's a really high-quality hosting platform. But they did something a few years ago as a result of lawsuits, which is content filtering. And you hear content filtering a lot in relation to the EU's Article 13, Article 17. Vimeo has actually been really mostly good about how they implemented this. They don't have their own content ID like YouTube does. They use a service called Audible Magic, which is the same thing, basically. You fingerprint your stuff with Audible Magic, and then it filters stuff as it hits Vimeo. So if somebody uploads a video to Vimeo, it will be flagged if it recognizes your music. And then basically Vimeo will say to the uploader, show us your license or tell us why it's a fair use. And it gets kind of dicey here because if they can't provide a license, then the video has to stay private, which really defeats the purpose of them being able to use the service. So in that way, it's kind of good. The downside to this, I learned, is that the Vimeo itself is making the fair use decision. So the uploader can say, I used Kerry's piece for 6 minutes of this dance performance that's like a promo for my dance company. And this is fair use because it teaches people about dance. And Vimeo will say, well, you used the whole thing, so it needs to be a shorter excerpt. And this is an actual example, by the way, because the person I nailed actually sent me the email chain. And Vimeo said, well, you used the full thing. So the person cut it down to 3.5 minutes, and then Vimeo said, okay, we'll buy your fair use argument now. So Vimeo, who is incentivized by keeping that user, because they're paying $19.95 a month for the platform, is making the fair use, telling that user that, okay, we think this is a fair use. The piece that's missing here is that there's no notification to me at all that it happened, that it was uploaded, or that a fair use decision was made. I only found that use in particular because they credited my name right before they copy and pasted that fair use language that you can Google. This is disclaimer, educational, fair, everybody's seen it, right? So Vimeo has actually been really good, but there's some things that need to be ironed out.
In the back, there's a question.
So I have a different view on why YouTube implemented Content ID, because they figured out how to make money from it. It's very simple. Earlier this morning, we had a presentation that showed, and I'm sorry, I forget which one it was, that showed what the most popular videos are, and most of them are music. I think that Google, which owns YouTube, figures that they could get the record companies to agree to this scheme and thereby get all the traffic from all their material. They made a gamble, and it paid off. Now YouTube is by far the largest streaming music service in the world, greater than all the others combined by at least a factor of 2 by user volume. It's just simple. They found a way to make money off of it. Instead of regarding it as a way to keep content off, they figured out how to get the revenue in. It's that simple.
Yeah, I read something recently that said that the major labels were making $10 million a day in monetizing YouTube videos that had their music in it. From that kind of monolithic standpoint, it's spectacular. If I was making $10 million a day from monetizing infringements, I'd leave it alone. Like, I sure wouldn't touch it. Right, that's like 99% of YouTube is governed by those agreements. It's the little tiny 1% that I happen to fall into. And unfortunately, there's no remedy for that.
So we're at the end of time. I'll give you each like 10 seconds to close on a positive note. What opportunity do you see in the next 20 years if we iron things out?
Unlike what my impression may have been, I'm actually quite optimistic that we can turn this thing around. And starting from the reforms that Maria Palante kind of got into flow and the way they're moving, I think there is hope. There's some real interest in the Senate. There's recognition that there are problems. It's just going to take
and Copyright Office.
starting with, yes, CASE Act, copyright modernization, get the thing efficient so we can get us into the system,
Right.
and then rethink it, a few things, and
Ben.
it'll work better.
Yeah, so I was positive to begin with, so I think that
Be negative now.
we'll invent solutions. I mean, if you looked at all the naysayers throughout history, whether it was everybody from prophets to Malthus to others who said that we'd run out of food, we'd run out of air, we'd run out of water, we'd run out of everything, we figured out ways to overcome that, and I think that it's done by creative people who have a vision and who want to change the world, and if government can help them a little bit, all the better.
Josh.
Well, I'm volunteering full-time to fix it, and a lot of people are joining me every day, so that's my hope.
All right. And Kerry, close us out.
I think that the CASE Act and the MMA are good harbingers of things to come, and I'm hoping to see a revised DMCA in my lifetime. It can happen.
On that note, thank you to the panel.